Good morning, everyone. My name is Allison DeGuide, and I'm with the Illinois Restaurant Association. I'd like to thank you for joining today's webinar on legal updates for the hospitality industry. Today's webinar is being broadcast in English, Spanish, and Mandarin Chinese. To listen in Spanish or Chinese, please use the interpretation button in your toolbar. This webinar is being presented by the Illinois Restaurant Association in partnership with the Cook County Small Business Source. Established to ensure businesses emerge from COVID-19 intact and positioned for growth, the Small Business Source connects small business owners with expert guidance and support. Services include no-cost business advising, resources, and events that connect small business owners with a community of advisors. For one-on-one business advising, sign up at cookcountysmallbiz.org. It's free and easy to sign up. Also, before we begin, I'd like to everyone attending to know that the Illinois Restaurant Association remains a resource to you. We send regular email updates with what you need to know, and you can sign up for those on our website. For today's webinar, you can use the Q&A button to post your questions at any time during the presentation, and we'll do a Q&A session at the end. At this time, I'd like to introduce our panelists, Robert Bernstein, partner, Lehner Muchin. Rob, please take it away.
Thank you, Allison. Thank you, Teresa, the whole IRA team as well for putting this together. Always great to be with you and impart, updates that are important for all your members to know. You've probably heard me say this in other webinars, but I tell you, when you look at this time frame that we're in, I cannot remember a time frame when there's been so many things to worry about in terms of labor and employment law and ordinance and other updates wise. So it's a very timely point to do this webinar, particularly with the new July 1 dates coming up for the effective date of the Chicago paid leave law. We're going to talk about it, but the new minimum wage law. So it's a really timely time to be giving people a reminder of these things. I'm going to say up front, like I always say in these webinars, look, if you have one-off, more complicated questions that pertain to your restaurants or your businesses, I'm always happy to answer them. You have my email, you have my phone number. Just contact me offline because I know we have a lot of people on this webinar today, and we're not going to be able to get to all the questions, especially those that are nuanced as it relates to your businesses. So with that said, I'm going to jump right in because there's a lot of material. And Teresa, do me a favor. Teresa's nice enough to turn the slides for me today so that we can keep this moving. I appreciate that. And we're going to go to the first slide. Yeah, perfect. Let's start here. So I want to give an overview of these things. When I say these things, these different laws, there's three different laws, okay, in terms of the paid leave area. The first one is the Illinois Paid Leave for All Workers Act that went into effect on January 1 of 24. The second one is the Cook County Amended Paid Leave Ordinance that went into effect on December 31 of 23. And the new Chicago Paid Leave and Paid Sick and Safe Leave Ordinance, we were waiting, but we now know it's going to go into effect July 1 of 24. And there's been new regulations. If you go to the BAC, the City of Chicago website, there's been new regulations put out there over the last, month to 2 months that go into interpreting, different provisions of that law. Okay. One of the most important things, and the one area that if you're not is into the weeds on this is I am and my firm is, I just want to be clear which laws pertain to you. Okay. That's a really important question, or which law, or it could be laws. But so I want to keep this simple, and there's a slide later on in this. And by the way, you're going to get the slides after the presentation, so don't feel you have to write down everything I'm saying. You're going to have the slide deck. But what I was going to say is this. Let's keep this simple. If you have a location in the city of Chicago, okay, you have to comply as it relates to that location or those locations. You have to comply with the new Chicago paid leave and paid sick and safe leave. Just like you had to, you guys know that the Chicago paid sick leave law went into effect in July of 2017. So it's been like 7 years you've been complying with that, okay? And so this is a new law, though, that expands employees' rights. And if you have as it relates to your Chicago establishments, you need to comply with the Chicago paid leave law. The new law that's coming up 7/1/24, and there's a variety of things you need to do to comply. If you have a location in Cook County, okay, that's outside of Chicago, even if it's one of those municipalities that previously opted out of the earned sick leave ordinance that went into effect 7/1/17. For those Cook County establishments, you should comply with the Cook County amended paid leave law. And that law is different than the city of Chicago's. Okay. And then for the Illinois leave law that went into effect January 1 of 24, if you have an establishment that's outside of Chicago, outside of Cook County, that's the law that you need to comply with. Now, I've gotten a question from, my firm. We represent a lot of, obviously restaurants, but a lot of restaurant groups that, have a significant number of establishments. And I've gotten a question at times, can you be more generous and have like a common denominator among the different locales? And of course, you could be more generous than the law if you want to administratively give people the same thing. But I'm telling you as a baseline rule, which ordinances you have to comply with depending on where your establishment is. So to take a really simple but illustrative example, let's say you had a Chicago-based restaurant, okay? And let's say, I'm just giving a number. Let's say you had 50 employees there, 50, okay? Well, if you were just complying with, I'm just going to say, the Cook County law for those people, or the Illinois law for those people, you would be violating the law, because you need to comply for those Chicago people with the new Chicago paid leave law that's coming down the pike and going to be effective beginning next Tuesday. Okay, does everyone, I'm sorry, I said Tuesday, next Monday, not Tuesday, Monday. Okay, Monday, July 1. All right. So I just want to be sure on coverage that everyone's clear as to which law pertains to you. Now, we have many multi-establishment restaurant groups where all these laws apply to different of their locations. It just depends where they are. And sometimes they don't want to give the more generous because these laws are very expensive as they are in today's very difficult times to operate restaurants. So just know which ones apply to you. Let's go to the next slide. Okay, so the one I want to spend most time on today, I want to spend most time on the Chicago paid leave law. Okay, well, I'm going to talk about the other two laws, but because this is new and because it's going into effect on Monday, and because I just know, from the IRA's membership population, that I'm sure this pertains to a number of people on the call. All right, and I want to spend most time on that. So let's high level overviews, maybe not so high level, but fairly detailed. So stay with me. I tried by creating these slides to be as helpful as possible to you to hit on the most high points of the law. Okay. So it goes into effect Monday, July 1. I've said that multiple times. Okay. If you're asking who does the law apply to, it applies to any employer who at least employs, who employs at least one employee. So it's going to pertain to most any restaurant. Okay. It applies to employees who work within Chicago for at least 80 hours within within a 120-day period. So basically within a 3-month period, the employee needs to have worked at least 80 hours to be covered under this law. And I've gotten the question multiple times, does it pertain to part-time employees and seasonal employees as well as full-time employees? And the answer to that is yes. Okay, now, we sometimes have clients that have different policies for those different classifications of employees in this area. And so long as you're giving the minimum that's required under the law, that's acceptable. Okay, but if you want to talk about nuances and how different places are structuring these things, we can talk offline. Okay, this law provides paid sick leave, and you see in all caps, and paid leave totaling 88 hours in a year. That is a richer or greater benefit than the Illinois and the Cook County laws. Very important, guys. Very important. This new Chicago law says for 80 hours in total, 40 of paid sick leave and 40 of paid leave every 12-month period. Okay, so you can handle this compliance through an accrual method, just like many of you did for the paid sick leave ordinance. It's been around for a long time in Chicago, and that would be 1 hour of paid sick leave for every 35 hours worked. Notice, let me pause. This is 35 hours. The prior paid sick leave was for every 40 hours. This is another change. 1 hour of paid sick leave for every 35 hours worked, up to 40 hours in a 12-month period. Paid leave, it accrues 1 hour of paid leave for every 35 hours worked, up to 40 hours in a 12-month period. And it begins upon the 12-month period of employers choosing after July 1. Okay, so you can pick the 12-month period, but the law goes into effect July 1. If employee already accrued paid sick leave prior to July 1 of 24, then those, from the prior law, then those hours carry forward. They aren't extinguished or wiped away just because this law changed. Okay. Paid sick leave and sick leave accrues in hourly increments unless you use the front loading method, which is an option. If you dump 80 hours total, 40 of each into a bucket, beginning July 1 of 24, that's acceptable as well. We'll talk about that as an option coming up more as well. Okay. Most employers, in my experience, it doesn't mean that you have to, and you got to pick the one that's right for you, go with the accrual method. It's more time consuming and administratively more of a hassle to, track and make sure you're complying with. But I'm assuming that many of you, unless it's the smaller restaurants who may do your own bookkeeping, I'm assuming that many of you use a payroll service externally anyways, and they should be helping you to set this up. Okay. So bottom line is, keep going. Let's go to the next slide. Accrual. Some tips here. Hours worked outside of Chicago don't count towards the accrual. Like if you have an employee that works multiple locations and they're working in a place outside Chicago for some of it, you don't count those toward the accrual unless you want to. Overtime hours count. Okay, we know in you have to pay overtime for any hours worked above 40 in a work week. Those count toward the accrual. In lieu of accruing time, employers may front load 40 hours of paid leave and 40 hours of paid sick on the first day of the 12-month period you pick. Okay. Once an employee is covered, the employee stays covered for the remainder of the employee's employment. What's the carryover rules for paid leave? The paid leave portion of this carryover is 16 hours in a 12-month period, if not front loaded. Okay. If it's front loaded, then for the paid leave part, you can avoid the carryover. All right. Paid sick leave, you have to allow up to 80 hours for the carryover from year to year. Okay. Paid leave can be used for any reason. Paid sick leave can be used for employee and family members' illness, injury, victim of sexual or domestic violence. The business is closed for a public health emergency and other reasons. There's payout at separation or termination for paid leave only. There's no payout required for paid sick leave unless you want to. You should have a legally compliant policy for this law. And we've obviously been spending hours and hours with our clients helping them develop them. If you have any questions about what needs to be in the policy, ask whoever it is you would ask, or ask me. It's very important that you would say things like, if you're not going to do it, that upon separation, there's not going to be payout for paid sick leave. Okay. The payout for paid leave upon separation is dependent on the size of the employer. You could see here, depending on which bucket you fall in terms of the number of employees, that's what triggers the payout. If you're a small employer, 50 or less employees, there's no payout of paid leave required. It's only if you're in the 101 plus employees and the medium employers, 51 to 100 employees. Okay, next slide. Some other high points of this new Chicago law that's going into effect on Monday. Paid leave, in terms of when can you use it, no later than 90 days after starting employment. For the paid sick leave, no later than 30 days after starting employment, okay? Employer can restrict the use of paid leave or paid sick leave to employees' regular work week, okay, i.e. mandatory overtime or weekends, all right? So you can restrict of it to the use of just the regular work week, and if there's mandatory or overtime or weekend work that's beyond that, you could say that, you know, that you can't use it then, okay? As long as you're doing that in a reasonable way. You can require, it's a big issue here that we've gotten a lot of questions on. Ask me offline if you have any more details on this, but the employer can require reasonable pre-approval under this new Chicago law, and also deny paid leave requests, but must do so in writing. If it must, they can deny them if it's an unreasonable situation, okay, where they're not getting reasonable pre-approval. They don't go through that step, the employee. Okay, so you can deny it in those circumstances as long as the employer is being reasonable in the pre-approval that they're required. But you must do so in writing. The employer must deny it in writing, stating the reasons for the denial. And you want to keep a record of that. Keep that documented in your file. For the employee. The employer must consider the following factors when denying a request: whether granting paid leave would significantly impact the business operations, if the employer provides a need or service critical to the health, safety, or welfare of Chicago. Similarly situated employees must be treated the same, and the employee still has to have meaningful access to use of the paid leave. For paid sick leave, an employer may require a note after an employee uses paid sick leave 3 consecutive work days in a row, okay? So if you had an employee that called you on a Friday and that was their first day and they said, I'm not feeling well, you can't say to them, give me documentation for that Friday, because that wouldn't be 3 consecutive work days in a row yet, okay? Employers must maintain records of paid leave and paid sick leave for each employee for a period of 5 years. Make sure you're keeping meticulous records in the event that you're ever audited by the city, or in the event that you're ever sued by an employee. Because one thing you're going to see under this new Chicago law, there is a private right of action which allows employees or former employees to sue employers in court for enforcement of this law, okay? Who is a family member for paid sick leave? Take a read of this. You're going to get the slides, but I'm just going to leave you with, it's very broad, guys. It's very broad in terms of who constitutes a family member for paid sick leave purposes. Take a read of this when you get the slides, okay? Next slide. These are some things that are very important that as we, know that this Monday date is coming up, that you have to do. You must post the city-created notice through the employer's usual mode of communication for such notices. And I put the link there for you to get the notice, okay? And post it in a prominent spot where your other posters are, guys. You want your employees to definitively see it, okay? Employer must provide notice to the employee within the first paycheck subject to the ordinance. And I said it goes into effect this Monday, okay? And prior to the commencement of any new employee's employment thereafter, and that you have to provide the notice annually with a paycheck issued within 30 days of July 1 of that particular year, okay? Notices must be provided in English and any other languages if 5% or more of employees are not literate in English. You should establish a new paid leave and paid sick leave policy and work with whoever it is that you're working that understands the law and what needs to be in there, okay? And you should include in there advance notice procedures and the basis for denial of paid leave requests. It may be part of a manual, an employee handbook, or a separate document, but you're going to want to make sure that it's distributed to your employees and that they sign off on receiving it, okay? Provide notification to employees of the availability and use of paid leave. And you do that by, if you guys use a payroll system, a payroll company, well, you should be keeping tracks. They should be keeping track of usage, how much is left on each of the pay stubs. It should be different line items, so it's very clear, okay? How is the employee count determined for purposes of payout? Number of employees are aggregated if they are employed by members of a single unitary business group as defined for Illinois Income tax purposes. Ask me if you have any questions on that. We get frequent questions on this as to whether or not, how employee numbers are aggregated, and it depends on how the businesses are structured. So we can talk about that, okay? Front loading is allowed for both paid leave and paid sick leave as opposed to the accrual method. Front loading prevents 6 hours of paid leave from carrying over. You don't have to comply with that, but it does not leave the up to 80 hours of paid sick leave carryover obligations, even if you front load. Okay, next slide. A lot of places, by the way, don't like to front load because, again, I'm generalizing, guys, but because of the high turnover rates in the restaurant and hospitality industry, and they don't want to put all that leave up front. Rather, they prefer to go the accrual method, for that being one reason that I just mentioned, turnover. Okay. Does an unlimited paid time off policy comply with the ordinance? It requires a fact-specific analysis, but factors are: do the employees have reasonable access and ability to utilize at least 80 hours of PTO in a year? What's the rate of pay for the PTO time that is used? Notification and approval policies for the usage of PTO time. We have more clients that now have unlimited paid time off policies, but I would still say it's in the minority of clients, but more are doing that. And you just be mindful of these things if you're going to attempt to use that as a mechanism to comply with this law. One thing that comes up, guys, is do you have to provide this additional 80 hours under this law if you have an existing policy or policies that already provide it? Well, what's the answer to that question? No. You can comply with this law through an existing PTO and sick leave policy or sick leave policy, so long as it's clear in the policy that you're giving at least the threshold minimum that's required under this new law, at least, and that you comply with the other tangential factors of the law, some of which we're going to talk about, and that you have a legally compliant policy or policies. So this isn't saying that if you were, I'm just going to use a stark example. If you were giving, if you're giving, just again, a simple example, if you're giving 50 hours of paid leave or PTO now, and 40 hours of paid sick leave now to employees in a 12-month period, okay? Well, you could comply with this law as long as you keep doing what you're doing. You don't have to give now 90 hours of paid leave and 80 hours of paid sick leave. You're not adding this new time onto your policy. Let's be real clear about that in any of these statutes, okay? So if you have an existing policy or mechanism where you're complying with this already, look at the regulations. It speaks to that, the new regulations. And you can comply with your existing policy so long as you're doing at least the minimum and that you're complying with the ancillary features of the law, okay? Rates of pay. Employees must receive their regular rate of pay when using paid sick leave and paid leave, which includes continuing health care benefits if the employee already receives them from the employer. The regular rate of pay is calculated by dividing the employee's total wages by total hours worked in full pay periods of the prior 90 days of employment. Wages do not include overtime pay, premium pay, tips or gratuities or commissions for the rate that's used to pay paid leave. Next slide, please. Incremental usage under the new Chicago law. Employers must offer a minimum of 4-hour increments usage for the paid leave, and paid sick leave must offer a minimum of 2-hour increments. I mentioned this is important. There is a private right of action whereby employees can bring a lawsuit in Cook County Court here against employer for violations. That private right of action for paid sick leave violations goes into effect July 1 of 24, and for paid leave violations goes into July 1, 25. You can see that there can be fines of $500 to $3,000 for various violations. You can get triple damages in certain instances for these violations, and you could get your attorney's fees. So there's big stakes here. Make sure that you're following these laws meticulously, okay? Any of them, whichever apply to you. Paid leave in Chicago, paid leave in Illinois, amended paid leave law in Cook County. Statute of limitations from bringing a lawsuit under The Chicago paid leave law is 3 years from the date of the last violation. Okay, I know because we represent so many of them. I know that in terms of the number of unionized restaurants, I could count on 1 to 2 hands in the city of Chicago, probably. Okay, there's not that many of them, but to the extent that you have an existing collective bargaining agreement that's in place prior to July 1 of 2024 and pertains to a segment of your employee population, that this law does not pertain to you as it relates to that bargaining unit for the time being, because you had a pre-existing collective bargaining agreement, and that's what governs. However, if you go to negotiate a new collective bargaining agreement that goes into effect after 7/1/24, that this law would pertain to your bargaining unit employees unless you get a express written waiver in the collective bargaining agreement saying that the union waives their right to have employees, get this benefit. Okay. Some other things about the new law: employer pre-approval policies. It should be in writing. It should consider business operational needs. Does the employer's business include health, safety, or welfare of the people of Chicago? Are similarly situated employees treated the same? Employees have to have meaningful access to paid leave they're entitled to. You should keep records in a safe spot, in an easily found spot, in an organized way for 5 years in terms of people's leave usage. Again, at any point, you could be audited by the city due to a disgruntled employee, or there could be a suit. You want to have meticulous records. You don't want to get caught without having good records, because that's going to be construed against you, just like the wage and hour laws are if you don't have records that you paid overtime and other things like that. Okay. Employee's name and contact information should be there, the start date and the separation date, job classification and titles, full-time, part-time, seasonal, hours worked, rate of pay, leave earned, leave used, and remaining leave balances. Again, if you work with a payroll company, all this should be meticulously listed on the pay stubs. Okay. What can you not do, and what do you want to stay away from doing under this new law as an employer? You can't ask an employee to find a replacement or coverage as a condition of using the leave. So let's pause for a second. When I was talking about making sure as soon as possible, if you don't already, that you work with someone that knows what they're doing to establish a legally compliant policy in this area and make sure it's disseminated. And I was saying that beyond the amount given and how that works accrual wise or front loaded wise, you need to have the ancillary features of the law documented in a policy. Well, this is a good example of something I would want in your policy, that the employer can't, we would word it differently, but that an employer can't force an employee or mandate an employee to find a replacement or coverage as a condition of using the leave. You would want to say that in case you're ever audited or there's a lawsuit. You would want to be on record that you understand what the law is. And that's an example beyond the amount of something that you would want. You would want an anti-retaliation provision in there, that you don't tolerate or that you don't engage in any retaliation if someone seeks to exercise their rights under this law. That you won't interfere with their rights under this law. You cannot pay an employee not to use leave. You can't change a schedule to avoid leave. You can't discipline for using the leave. You can't document a reason for the paid leave, for the paid leave part. Remember, for the paid sick leave, you can, if it's at least 3 consecutive work days, you can ask for documentation. Okay. From the healthcare provider, presumably. Okay. No notices. I mean, there could be reasonable pre-approval required. All right. You can't use incorrect increments. You heard about the minimum increments that we need to use under this new law. So what are the next steps practically for all of you on the call? And I'm hoping you've already, begun this, but if you haven't and you have any questions, obviously Monday's July 1. Let's get on top of this as soon as possible. You should review the Chicago ordinance and the regulations that have been out there for the last month or two on the Chicago agency website. They have some very good Q&As, and you should read those. Ask your labor and employment lawyer or whoever you work with, human resources consultant, et cetera, to make sure that you understand the laws and beyond this. And if you have any question, those are getting answered. Ensure your policies, notices, record keeping, and other practices comply with the requirements that are going to become effective Monday. Okay. And also and also ensure policies comply with the Illinois Paid Leave for All Workers and Cook County amended paid leave ordinance is relevant to your business, which took effect January 1 of 24 and December 31, 23. Those are old news already. I mean, you guys, to the extent you have businesses there, should have already been complying for a while with those, okay? Post the city-created notice of the new ordinance requirements using the link that I gave you, okay, in a prominent spot. And if it needs to be translated based on that criteria up above, I would err on the side of translation. In posting the translated version and having your policy translated. If a good segment of your population speaks Spanish, as an example, have your policy, just like I always say to clients, have your handbook translated. You don't want to be able to be legitimately accused that they didn't understand it, okay? Adopt a written policy explaining paid leave and sick leave rights and responsibilities, and share the policy with employees and have them sign off on it. Provide employees with paid leave and paid sick leave accrual and document information each pay period. Have your payroll company help you with that. Provide a copy of employment policies, including the new paid leave and paid sick leave policies to workers with regular work duties in Chicago in the worker's primary language. Give employees 5 days notice of any changes to the paid leave or paid sick leave policies and 14 days notice of any changes to any other employment policies. And train your managers and staff. We're doing a lot of training, my firm, on a variety of labor and employment topics, including anti-harassment and other labor and employment laws that they should be complying with. And this is one where you should make sure that they're trained and make sure that your staff, by someone who understands the law, understands how to administer these things, because they're going to be your eyes and your ears and your front line on making sure that there's compliance. Next slide. Okay. I want to just take a few minutes to go over a law that's been in effect already for about 6 months now, right? And this is the Illinois Paid Leave for All Workers Act, right? Again, if the city of Chicago law applies to your establishment there, then you got to apply with the city of Chicago law that we just mentioned, okay? But real quickly, this law in the Illinois law and the Cook County law basically mirror each other, and they are different than the city of Chicago law. The city of Chicago law is more generous to employees, okay? The Illinois Paid Leave for All Workers Act says that on January 1 of 24, that act went into effect, and it provides paid leave for nearly all employees in Illinois, provides 40 hours of paid leave each year for any reason to be taken at a minimum of 2-hour increments. Let's go to the next slide. Under the Illinois law, by the way, this is for establishments outside of Cook County, outside of Chicago, okay, in the state of Illinois. Employers must allow full-time and part-time employees to earn and use up to 40 hours of paid leave during a 12-month period. Employees must be allowed to earn paid leave at a rate of at least 1 hour for every 40 hours worked. Only hours worked count for accrual. Unpaid leave and PTO time does not accrue leave time, okay? So if you're taking PTO, you don't get more hours of from an accrual standpoint of paid leave. Employers can instead front load 40 hours of leave at the beginning of the 12-month period. What is paid leave? It's leave that is taken for any reason or no reason at all and may not have to be paid out upon separation. But let's be clear about this, okay? I get this question all the time. If you choose to comply with this law, and again, you don't have to give 40 more hours if you already through your PTO or vacation policy are giving a minimum of 40 hours per 12-month period. As long as you're complying with the accrual or the front load approach under this law and in the other ancillary features of the law, it's not set up so that you have to give 40 more, okay? But if you choose to comply with this law through an existing PTO or vacation policy, and you don't earmark this as separate paid leave under this law, you do have to pay it out upon separation because it's wages. So the best way that you could try, if you don't want to have to pay this paid leave out, is to have a separate policy that's called paid leave under the Illinois Paid Leave for All Workers Act, and treat that as separate and apart from PTO or vacation. A lot of places don't want to get into the administrative hassle of doing that, and they comply through PTO or vacation policy. You just need to know that if you do that, you have to pay out the paid leave upon separation under this law, okay? Employees do not need to submit documentation or proof to support the leave. Employers must allow employees to begin using paid leave 90 days following the beginning of their employment or 90 days following the effective date of the act, whichever is later. Employers with existing paid leave policies that provide for at least 40 hours of paid leave need not provide any more so long as employees can use the paid leave for any reason. Okay, next slide. What's the rate of pay that you paid leave at? The regularly hourly rate. So and also for tipped and commissioned employees, you have to pay at least the full minimum wage in the jurisdiction they work. So that would be 14 bucks an hour in Illinois. You can't pay them at the tip credit rate or the commission rate. It's got to be the full minimum wage rate in the jurisdiction. And for Illinois, that rate is 14 bucks now. For the city of Chicago in Cook County, that rate is higher, obviously. We're going to talk about that in a minute. But for Illinois, it's 14 bucks an hour now, okay? The blackout dates, an employer can deny an employee use of paid leave as long as you have a reasonable policy on that outlines the reason they deny paid leave, or that they can deny them. And it's got to be due to operational necessity, including holidays, busy periods, or peak seasons. And you want to treat similarly situated employees the same in your approach here. The policy must be in writing and communicated to employees, and you want to have them sign off on it. Is there paid leave for no call, no shows? An employer can prohibit this by adopting a reasonable policy regarding notification for unforeseen absence and how they will handle no call, no show absences, but employers cannot require the employee to disclose the reason for the absence. Okay. Next slide. What can't you do as an employer under this Illinois paid leave law? You can't ask an employee for the reason for their paid leave request. You can't ask an employee for documentation relating to their paid leave request. You can't require an employee to find a replacement before they can use their paid leave time. And it's unlawful for an employer to consider the use of paid leave as a negative factor in an employment action. And employers may set increments for use of paid leave at no greater than 2 hours. Okay. There's some exceptions. Independent contractors, if they're a valid independent contractor, make sure you get that right, because that's a very important point. You don't want to get that wrong and misclassify people. And then take a read of these. Most of these other ones aren't going to apply to the restaurant industry, but I just wanted to mention them. Okay, next slide. This Illinois law applies to employees who work through a temporary staffing agency. I know certain places do use hospitality staffing agencies. And in that instance, the staffing agency, because they employ that individual, we're not the employer of that individual, except, under the discrimination laws and harassment laws, we'd likely be deemed a joint employer for that purpose. But the staffing agency is their employer, and they need to provide that paid leave to them. Employers may set the 12-month period they will use for paid leave, as long as it's clear up front to the employee and everyone knows. The employers must allow employees to carry over any unused paid leave at the end of the 12-month period, unless they front load paid leave. Employers are not required to allow use of more than 40 hours of paid leave in a 12-month period, though. There's a 40-hour cap in terms of usage if an employer wants to avail that rule or invoke that rule. Okay. Employers may set notice procedures for paid leave. If the need for paid leave is reasonably foreseeable, employers can require employees to give up to 7 days notice. If the need for paid leave is not reasonably foreseeable, employers can require employees to give notice as soon as practicable. And that should be spelled out in your policy. Okay. If you want to adhere to that. Unused paid leave need not be paid out upon termination. Remember what I said, though. If you comply with this law through PTO or vacation and you lump everything together, it's got to be paid out, okay, upon separation. However, any unused leave must be immediately reinstated if the employee is reemployed within 12 months of termination. And if you have a pre-existing collective bargaining agreement that was in effect as of January 1 of 24, this law doesn't pertain to you. It does pertain to collective bargaining agreements that are negotiated after, in which case you would have to get a waiver if you didn't want this express written waiver in the collective bargaining agreement if you didn't want it to apply. Next slide. For remote workers, if you're wondering, in today's post-pandemic world, does it apply to remote workers? These Illinois workplace protections apply to employees who primarily work in Illinois for a company that does business in Illinois. Therefore, if an employee primarily works in Illinois, then the employee is likely entitled to pay leave even if they're working remote, okay? If an employee works less hours than anticipated or quits before the end of the year, an employer is not allowed to make the employee pay back the employer for front-loaded unused paid leave. That's why I was mentioning earlier, with the amount of turnover, generally speaking, that exists in the restaurant and hospitality industry, most employers are choosing the accrual method, okay? This is a big reason why. Overtime exempt employees, I know some of you obviously, or all of you have certain exempt employees, people that you treat as exempt from the overtime laws. And so if in that situations, employees who are exempt, let's say you have I'll give a stark example. Let's say you have a general manager of your restaurant who oversees the whole operation, that he or she's likely going to be exempt, I'm assuming, okay, under the executive exemption. And under this paid leave law, they'll be deemed to work 40 hours in each work week, even if they regularly work 40 or more hours. If they work less than 40 hours in a week and you track that, which you should be under since 2015, even if they're exempt under Illinois law, their paid time accrues based on the number of hours in it should be in their regular scheduled work week, okay? Unlimited PTO policy, it might be compliant with the act. It's a fact-specific analysis. The factors are whether the employee did or had the ability to take 40 hours of paid leave in a year for any reason, whether employees were paid the regular rate of pay for the time they took off, and other factors may be used but are not disclosed, okay? And employees can file a complaint with the Illinois Department of Labor for alleged violations of the act, but there's no private right of action like there is with the city of Chicago. There's 3-year statute of limitation, and you can see the penalties here. The penalties are heavy, guys. So you want to make sure that you're complying with these laws. Finally, the Cook County amended paid leave ordinance. Again, this only pertains to establishments in Cook County that are not in the city of Chicago, okay? And this law was effective as of December 31 of 23. It applies to employees who work for an employer in Cook County and or an employer as a place of business in Cook County. It's very similar to the Illinois Paid Leave for All Workers Act. Remember, I mentioned that. You can take a read of these things, very similar. Unused paid leave does not have to be paid out at termination. However, make an asterisk. If you comply with this law through an existing vacation or PTO policy, you got to pay it out. Same thing as under the Illinois law, okay? Does not apply to employers in Chicago. Like if you have a Chicago establishment, you have to follow the Chicago law, okay? And many of the municipalities, I mentioned this earlier, but to illustrate the point, when the Cook County Earned Sick Leave Ordinance went into effect on July 1 of 17, many of the municipalities in Cook County opted out of that, so they didn't have to comply. Those businesses that were in the municipalities that opted out. What this law says is you have to comply, even if you have a business in Cook County with this law, you have to comply, even if they previously opted out. Okay? Leave can be used for any reason. Front loading is allowed. Private right of action, there is a private right of action. You can file a lawsuit in court on this. Again, there's a 3-year statute of limitations. Payout, no, but employers are required to pay the value of unused paid leave if the leave is credited, as I've mentioned a number of times already, to the employee's paid time off bank or employee vacation amount. Must be paid within 15 days of that termination, resignation, retirement, or other separation. Be careful, vacation PTO must be paid out. I've said that 5 times now, so that's very important if you choose to comply through those policies. Employers may adopt policies that establish some parameters for taking leave, notice requirements, and limited reasons the employer may deny the leave for operational necessity. And policy must be communicated to employees and apply equally, and you want to get them to sign off on this, no question, okay? Repayment of paid leave, no, employer may not seek compensation from employees for front-loaded time used if they leave before the 12-month period. Record keeping, must maintain records documenting hours worked, paid leave accrued and taken, and remaining paid leave balance for each employee for a period of not less than 3 years. rollover, employees are allowed to, except when front loaded. You can front load and avoid the rollover under this Cook County law, same as in Illinois. Employees are allowed to carry over or roll over unused accrued leave from one year to the next, and employers may cap how much time an employee can roll over from year to year, but a cap shall not be less than 40 hours. 40-hour rollover cap is allowed, assuming you use a front load method. The rate of pay that this paid leave is paid out at is Cook County's current non-tipped minimum wage, which is $14 an hour. But as you're going to see, effective Monday, it's going up to $14.05. Okay. So just again, to hit home on this, what's the interplay of these laws? If your business is located in Chicago, you have to follow the new Chicago paid leave and paid sick and safe leave ordinance. Goes into effect Monday, July 1, 2024. Until Monday, July 1, 2024, you can follow the prior Chicago's paid sick leave ordinance that has been in effect since July 1 of 17. If your business is located outside of Chicago but within Cook County, follow Cook County's paid leave. If your business is located outside of Chicago and Cook County, follow Illinois' paid leave law, unless you want to be more generous in any regards. Okay, let's take a deep breath. That was a lot. But do please, I can't emphasize enough, make sure that you're complying with these laws and that you're doing the things that I mentioned about posting the notices, having a legally compliant policy, making sure you're tracking the leave, making sure you're keeping meticulous records of the leave. Can't emphasize enough how important that is to protect your business and evade potential exposure. Okay, next slide. Now I want to talk about minimum wage reminders. What's the Chicago minimum wage? As of July 1 of 24, the minimum wage, so that's Monday as well, the minimum wage in Chicago for non-tipped employees will increase to $16.20 per hour for employers with 4 or more workers, and the minimum wage for tipped employees will increase to $11.02 for employers with 4 or more workers. Okay, that's Monday. I say this, for those of you who've been on webinars with me, I say this all the time because I and my firm are maniacal about this. If you have tipped workers, which I'm assuming most, if not all, do on this call, okay, and you take the tip credit for them, okay, you want to give them a tip credit notice in writing that's signed off by them each time there's a change in the wage rate. So, i.e., now with this minimum wage rate coming up, let me be clear on something, okay? You don't have to do that under the law. You can verbally tell them what the arrangement is, the tip arrangement is, but you know what I'm going to say, that it's much better to have that documented with all your employees as to how that works in the event that you become embroiled in a lawsuit. Trust me, my firm defends tens and tens and tens and tens of these wage and hour lawsuits and Department of Labor audits. And you want to, if you are caught under a microscope there in defending yourself, if you have tipped workers and part of the claim is that they didn't understand how they were being paid or you're not following the tip laws, it would be much better to have a tip credit notice signed off for all those employees of yours that you are taking the tip credit on. Okay, couple things about this, very important. Let's take a pause here because I want everyone to focus on this. If you historically have not given a written tip credit notice to employees, okay, then you want to talk to someone who understands about the best way to communicate that change, okay, instead of just blasting it out. Number two, there's the devil is in the details in the drafting of these tip credit notices. Please do not pull it off the internet. Please don't pull a paid sick leave policy off the internet. Okay, that is fraught with risk in such important areas like this. Go to someone that understands these laws and drafts these laws all the time. And these documents, the tip credit notice documents, they're very detailed. The devil's in the details. You want to use correct parlance. You want to have someone behind that for you that understands what the law is in this area. And you could save yourself hours and hours and hours and thousands and thousands and thousands of dollars by paying for a couple hours of time up front. Trust me, guys. I've seen it over and over and over again. Okay. Chicago's tipped employees will also have the right to file complaints with the Office of Labor Standards. Penalties for failure to pay minimum wage under the Chicago minimum wage ordinance are unpaid wages plus a fine of no less than 500 and no more than 500 for each offense. Keep going. Illinois minimum wage as of January 1 of 24, the current minimum wage is $14 an hour and will increase to $15 an hour beginning January 1 of 25. That's for non-tipped employees. As of January 1, 24, the tipped employee current minimum wage is $8.40 per hour and will increase to $9 an hour beginning January 1 of 25. And look at the penalties. They're heavy. For the Cook County minimum wage effective July 1, effective Monday, is going up a nickel for non-tipped employees, and for tipped employees, it's going to remain at $8.40 an hour, okay? So take a look at these. Make sure you're using the correct rates. Let me pause again. I'm just trying to help you and protect you. I mentioned that, and I tell all my clients this, okay? I mentioned that we become embroiled in defending these wage and hour class actions and other lawsuits and audits all the time. That's a big part of what we do on behalf of our employer clients, okay? And sometimes, not because they're not great companies, they are, okay? But we're all humans. And my point is, from time to time, even if you use the best possible and the biggest payroll companies, check from time to time to make sure that they're using the correct rates, because there's human errors and these rates change, okay? So make sure that you're checking from time to time, okay? Please. I think I'm just trying to help you out. You'd be amazed. Sometimes there's just the wrong rate being used and it just wasn't caught. Okay, next slide.
Robert, sorry, I wanted to jump in really quick. We wanted to make sure we had time for questions, so I don't know if you want to go ahead and start now, or if you wanted to get through the last few slides.
Let me just get through a couple more slides. Is that okay? And then that's a great point, Allison.
Absolutely.
So there's the Chicago law phasing out the tip credit is going into effect on Monday. It's going to phase it out from July 1 of 24 through July 1 of 28. But those rates I gave you earlier are the correct rate, even taking into account this phase out. The Illinois law, we're waiting to see. There may be a phase out, but it hasn't been passed in some senses. So Illinois, it's not law yet. The Chicago law is law, but those rates I gave you are good law right now, okay? And then finally, before we open it up to questions, I just want to remind people, let's go to the next slide, that recently there's been some EEOC updates on guidelines on sexual harassments. So take a look at those. Those are at the EEOC website, www.eeoc.gov. Make sure we're handling these issues delicately. Make sure for those employers in the city of Chicago, you're doing the annual anti-harassment training and documenting that you've done it, and the bystander intervention training. And for employers outside of Chicago, there's the Illinois anti-harassment training requirement on an annual basis. If you want to talk about any of that, we are doing a ton of that. Let me know, and happy to discuss that with you. So with that said, Allison, I think I'll take a deep breath and I'll let you open it up to questions, if that's okay, for the last few minutes.
Yeah, absolutely. We'll try to get through as many as we can. I just want to remind everybody attending that we will be sending out the slides, and you also have Robert's contact information. So without further ado, one of the questions is, how should employers be documenting the mandatory breaks, 1 day rest and such? The IDOL is cracking down. If you don't document, they will penalize.
Right. So you should make sure that's a great question. Okay. Under the break laws. Okay. There's been some modifications to the Illinois 1 Day Rest and 7 Act. And you definitely want to have each day that the employee takes a break, you want to have that documented, that they took the full amount of the break. And, if you're not paying them, some employers do it different ways. Sometimes employers have it be unpaid, other times it's paid. Either way, you want to make sure it's documented. And if you're working with a payroll company, talk to them about the best way to document it, but you want to have each day break on a daily basis documented in case you're audited. Whoever asked that question is absolutely correct, that we are getting more and more audits of the agency, the Illinois Department of Labor, on break periods. A lot of times a disgruntled employee will go there and file something in that regard or raise a complaint. and you want to have records each day that they took that full break, and they can't waive the break in Illinois. They have to take it. Okay, it's got to begin no later than the 5th hour of a 7.5 hour consecutive shift. If it's not a 7.5 hour or more consecutive shift, you don't have to give that break. Okay, next slide. I mean, not next slide. Next question. Next question.
Okay, next question is, do we need to carry over all sick time from prior leave or only 80 hours of carryover per new law?
You have to, if then that's in one of the slides. I'm assuming it's the city of Chicago they're referring to, but it could also be the Cook County law because they had the prior paid sick leave. You have to allow carryover from what they had in their bank into the new period.
Okay. Someone asked, is paid leave the same as vacation hours?
Well, it depends on, that goes to the issue. It's the same from the perspective that you can't limit what it's used for, the reason. So it's the same in that regard. But remember, I was making the important distinction as it relates to payout upon termination. Okay. If you have for Cook County and Illinois, okay, because remember, Chicago payout of paid leave is dependent upon the size of employer you are. It's different in the city of Chicago. Remember, that's in the slides. But for the Illinois paid leave law and the Cook County amended paid leave law, if you choose to comply with those laws through an existing PTO or vacation policy and bundle all of them together, you have to pay that unused paid leave or PTO or vacation time out upon separation because it's wages under Illinois law. However, the best place you can be if you want to try to establish this, if you have a separate Illinois Paid Leave for Workers Act policy in your handbook and you treat that bucket as separate than your PTO and vacation policy, then you at least have a more compelling argument that you wouldn't have to pay that paid leave out under the Cook County or Illinois laws. So that there's really two parts to that answer, okay?
Okay. The next question, when are violators typically chased by regulators?
When are violators chased? What does that mean?
I believe it's I believe it's in reference to the paid leave.
Yeah, I think it means. Oh, now I got it. I'm sorry. When are violators, meaning employers? So
yes.
So it's a great question. So the most well-measured answer is it's unpredictable. But I will say this, the way that I see these things come up a lot are in a couple ways. Number one, you have a disgruntled employee or former employee, and they go to the agency, and that triggers a full-blown investigation. Okay? Or multiple employees go. Another way it could come up is if there's union organizing, or if there's grassroots organizations that are involved with the employees, and the grassroots organization or the union gets them to go to the agency. Okay, that's another way it comes up. Another way it could come up, I suppose, is if you just have a sophisticated employee. And the employee workforces are way more sophisticated today because of social media. And they go and they're familiar with the law, and they know the employer's not complying, and they rat the employer out. So it could come up in a lot of different ways. But let me tell you something. I've seen this more and more. Okay, obviously this law, the Chicago law, is going into effect 7/1/24. You are taking a serious risk if you aren't on top of these laws. Okay, serious risk. I'm just telling you. And I'm not being alarmist. I just want everyone on this call to be protected.
Okay. I think we're running out of time for questions. I want to make sure we finish on time. So I want to thank everyone for attending. I would like to thank you, Robert Bernstein, your partner at Lehner Mutual. I'd also like to thank the Cook County Small Business Source for their continued support. And following the conclusion of this webinar, as I said before, everyone will receive an email with links to the webinar recording, the presentation, and Robert's contact information. So thank you all for attending, and have a great day. And thank you
very much, Allison and I are again. And again, if anyone has any questions offline, you have my contact. Thank you so much, everyone.
Perfect.
Bye-bye. Bye.